Hello everyone and welcome back to Courts This Week by LiveLaw. I'm Debojeet and joining me as always is Advocate Awstika here. This has been a richly packed week. The Supreme Court delivered what could become a landmark judgment on hate speech, settling questions that have been pending for years. Bengal's elections continue to simmer in the courts right up to the counting stage. A distressing case involving a minor rape survivor saw the Supreme Court dismiss a curative petition from AIIMS itself and issue a direct call to Parliament to reform the law. The court also granted anticipatory bail to Congress spokesperson Pavan Khera and in doing so made some pointed remarks about the Assam Chief Minister Himanta Biswa Sarma. The 9-judge constitution bench in the Sabarimala reference pressed on with revealing exchanges, and the Allahabad High Court had sharp things to say about the harassment of interfaith couples. So let's get into it. The Supreme Court this week delivered what may be a defining ruling on hate speech, and it seems to have settled two big legal questions in one go. Walk us through it, Awstika.
So the court was dealing with a batch of petitions on hate speech, which simply put refers to speech that incites hatred or violence against a group based on parameters like religion, caste, or community. Now, the petitioners were divided. Some argued that India has a legislative vacuum, meaning there aren't enough laws to deal with hate speech. Others said the laws already exist, but they're not being enforced properly, and asked the court to keep monitoring the issue through what's called a continuing mandamus. The Supreme Court has rejected both positions. On the first, it has made it clear there is no vacuum. We already have provisions like sections 153A and 505 of the IPC that have now been replaced by the BNS that deal with hate speech. At the same time, it has left the door open for the union and state governments to consider whether amendments are needed. On the second issue, the court has refused to step in with continuous monitoring. It said it wouldn't be appropriate for the Supreme Court, sitting at the national level, to track incidents across different states. It also noted that doing so would effectively mean taking over functions that are meant for statutory authorities.
And what about CPIM leader Brinda Karat's petition, the one about election speeches by BJP leaders Anurag Thakur and Parvesh Verma? To recap, these speeches were both given against the backdrop of the then ongoing CA and RC protests.
Ms. Karat's petition was decided as part of the same batch by this common judgment, and the Supreme Court has said that based on the material placed before it, no cognizable offence was made out against Thakur and Verma. So the request for FIR registration has been rejected. But even while doing so, the court made an important, broader point. It said that public figures have to be especially careful about what they say. Their words carry weight, and in a diverse society like ours, they can have real consequences. So the expectation of responsibility is actually higher for them. Importantly, the court also dealt with the question of the requirement of sanction before the registration of an FIR, and it has said that the requirement of prior sanction under section 196 and 197 CRPC or corresponding provisions in the BNSS operates at the stage of taking cognizance and does not extend to pre-cognizance stage of registering FIR or investigation under section 156.3 CRPC or section 175.3 BNSS. Now, there was some confusion, especially in cases involving public figures, about whether prior government sanction is needed even at this stage, because sanction is required later for prosecution in certain cases. The Supreme Court has now clarified this position. It has said sanction is not required at the FIR stage. It comes in only later when the court takes cognizance. And this is important because in many hate speech cases, there are repeated allegations that the police don't register FIRs, especially when the person involved is someone in a position of power. In those situations, the complainant's only real option is to approach the magistrate. What the court has now made clear is that when that happens, the magistrate cannot be held back from ordering an investigation just because sanction may eventually be required.
And how is this judgment received?
The judgment has, of course, made some important observations, especially on hate speech and the responsibility of those in positions of power. And the clarification on prior sanction is practically quite significant. But at the same time, it is being criticized, and it's important to understand why. So I followed this matter quite closely, first as a Supreme Court correspondent, and then later in litigation working in the chambers of Advocate Nizam Pasha, who was one of the main arguing counsel in this case. So over the last couple of years, the Supreme Court had taken a very active role in hate speech matters, passing continuing directions, asking states to act, and really keeping pressure on enforcement. This judgment, in a sense, steps back from that, right? By specifically saying that there is no need for a continuing mandamus. But the concern is this. In hate speech cases, the problem, as we've already discussed, is usually not the absence of law, it's enforcement. And enforcement becomes particularly difficult when the person making the speech is politically powerful or holds office. So to me, the judgment feels a bit academic. It clarifies the law, but doesn't fully engage with the ground reality of how that law is or isn't enforced. My concern is that without the continuing pressure from the Supreme Court, implementation may weaken again. That said, there are two clear positives. First, the position on prior sanction is now much clearer, which is a real practical gain. And second, the court has been careful to say that just because it is stepping away from a continuing mandamus. In this case, it is not shutting its doors. It has expressly noted that constitutional remedies under Articles 32 and 26 remain available, even if they are extraordinary, as a safeguard where statutory authorities fail to act.
Our next story is something on everyone's mind. What's going on with the West Bengal Assembly elections? This is turning out to be one of the most anticipated and polarizing electoral contests we have seen in recent times. And alongside the political battle, there's also been a parallel legal battle playing out in courts, especially around the special intensive revision of electoral rolls and now even the counting process. So tell us, what's the latest here?
So the immediate issue before the Supreme Court was actually quite specific, but legally very interesting. The All India Trinamool Congress challenged the decision of the Election Commission to appoint central government and PSU employees as counting supervisors and assistants at every counting table. Now, the TMC's argument was essentially this. Since these officials are under the administrative control of the central government and the centre is run by a political rival, this creates a reasonable apprehension of bias in the counting process. So the challenge was framed in terms of fairness of elections, Article 14, and the broader principle that the electoral process must not only be fair but also appear to be fair. They also questioned why this requirement was being applied only in West Bengal and not in other states, and even raised serious issues about whether the direction had proper legal authority under the Representation of the People Act and Article 324. What's interesting is that this came after the Calcutta High Court had refused to interfere, and the Supreme Court even held a special sitting on a Saturday because counting was just around the corner. But when the matter was finally heard on Saturday, the Supreme Court essentially said, at this stage, no further orders are necessary and closed the petition. In other words, the counting process was given approval to go ahead on the Election Commission's terms.
And all of this is happening against a very charged political backdrop. So what we're seeing is a very high stakes situation, politically and legally.
Yes, and that intensity has been spilling into the courts for some time now. For instance, there was a separate PIL this week saying the removal of a UP cadre IPS officer, Ajay Pal Sarma, who was appointed as an election observer in West Bengal. He's been stylized in the media as somewhat of an encounter specialist, so his appointment sparked some political controversy. Now, whether that petition will have any real impact is doubtful at this stage because polling is over and counting is currently ongoing. But it does tell you something important in this election. Nothing is being taken for granted. Every step is being watched, questioned, and where possible, challenged in court.
The next story is deeply distressing. AIIMS had actually filed a curative petition to prevent the termination of a minor rape survivor's pregnancy, even after the Supreme Court had already allowed it. This week, that curative petition was dismissed, but there was also a parallel contempt proceeding. Awstika, walk us through what exactly happened there.
Yeah. The timeline is important to understand here. This starts with a petition filed by the mother of a 15-year-old seeking permission to terminate a pregnancy that had already crossed the statutory limit under the Medical Termination of Pregnancy Act. A bench led by Justice B.V. Nagaratna, taking into account her age, the fact that she was a survivor of sexual assault and that she did not want to continue with her pregnancy, decided that forcing her to carry to term would be violative of Article 21. That was on April 24th. After that, AIIMS first filed a review, which was dismissed on 29th April. Following this, they went a step further and filed what's called a curative petition. Now, a curative is a very rare remedy. It's essentially the last possible attempt to reopen a Supreme Court judgment, used only in exceptional cases where there has been a clear miscarriage of justice. That curative petition was mentioned before the Chief Justice's Court on the very next day, that is 30th April, where ASG Aishwarya Bhati made an impassioned plea. She argued that the fetus was 30 weeks old and viable and suggested that instead of proceeding with termination, the pregnancy could be carried to term and the child given up for adoption.
So what did the court decide?
In a decisive move, the Supreme Court refused to entertain that curative petition. The bench of Chief Justice Suryakant and Justice Joyamalla Bagchi repeatedly emphasized that this is a case involving a minor rape survivor and an unwanted pregnancy cannot be forced upon her. The judges also made it clear that doctors can advise and place medical facts before the patient, but they cannot override her decision. Ultimately, the choice has to remain with the girl and her family. In fact, the court pushed back on the framing itself, saying this cannot become a contest between the state and the individual. The focus must remain on the rights, dignity, and well-being of the girl. So the curative petition was dismissed and the court stood by its earlier order allowing the termination of pregnancy.
And there's also a larger point the court has made on the law itself.
Yes. And this could have long-term implications. The court has asked the centre to consider amending the law to remove the time limit for termination in cases involving minor rape survivors.
But this story doesn't end there, right?
No, it doesn't. On the same day as the dismissal of the curative petition, a separate contempt petition was heard in which it was alleged that the Supreme Court's original order allowing termination was not being implemented. Taking that seriously, the court issued a clear warning. that if its directions are not complied with by May 4th, that is Monday, it may proceed to frame contempt charges.
Manipur, a situation that has been before the Supreme Court for the better part of 2 years. This week, the focus was on audio recording allegedly involving former Chief Minister N. Biren Singh. So what happened here?
Debojeet, there's a whistleblower in this case who claims to possess an audio recording of former Manipur Chief Minister Singh, a recording whose contents are said to be significant to the court's scrutiny of the ethnic violence that has devastated the northeastern state. These tapes surfaced in the middle of ongoing proceedings before the Supreme Court, and shortly thereafter, Biren Singh stepped down as Chief Minister, as we all know.
And what are the contents of these leaked audio recordings?
So according to the petitioners, these recordings allegedly contain statements where a voice believed to be Biren Singh is heard speaking about the violence in a way that suggests a degree of knowledge and even possible involvement in how it unfolded. Some portions, as claimed, indicate that the speaker is taking credit for initiating certain actions during the conflict, referring to it as almost a planned operation of war. There are also allegations about the use of force, access to weapons, and decisions taken at the state level during that period. Now, these are obviously very serious claims and they are strongly disputed. The state has maintained that the clips are doctored, which is why the Supreme Court is also proceeding cautiously by trying to assess whether the recording is authentic. And to that end, this week the Supreme Court directed the whistleblower to provide a first-generation copy of the recording, meaning the original file, directly from the recording device, untouched by any further copying or editing for forensic analysis.
And why does the first generation aspect matter so much?
Because every generation of copying introduces the possibility, real or alleged, of tampering. If you only have a copy of a copy, it becomes far harder to establish authenticity. By insisting on the first generation version, the court is being forensically rigorous.
So what I'm hearing is if the recording passes forensic muster, it could become a very significant piece of evidence in the court's ongoing examination of how the Manipur violence unfolded and how it was or was not addressed by the state's highest authorities.
Exactly.
And now from Manipur to its sister state, Assam. The Supreme Court this week granted anticipatory bail to Congress spokesperson Pavan Khera in an FIR filed by the Assam police. But it's what the court said, especially about the Assam Chief Minister, that has really caught attention.
That's right. At one level, it's a straightforward anticipatory bail case, which just means protection from arrest. The FIR was based on allegations made by the Chief Minister's wife after Khera made certain claims about her holding multiple passports. The Guwahati High Court had refused bail, saying that police needed to question him in custody, but the Supreme Court did not agree. It said this looks like a case driven by political rivalry and that there is no real need for custodial interrogation right now.
But the court didn't stop there, of course.
Yes. And this is where it gets interesting. The court actually referred to statements made by Assam Chief Minister Himanta Sarma and called them unparliamentary. Now, for the Supreme Court to say that in a bail order and to bring in the conduct of a sitting Chief Minister...
It's quite unusual. So, what did the court say here?
The court basically said two things. One, that Khera's statement appears to have been made for political mileage. But at the same time, it also pointed out that the Chief Minister, who is directly connected to the complainant, had himself made several unparliamentary public remarks against Khera. So the court is recognizing that this isn't a one-sided issue, it's a political back and forth on both sides, which is why it's reluctant to allow arrest at this stage.
And this isn't the first time the Assam Chief Minister has been in the news in the context of the Supreme Court.
No. If you remember, in February, there were petitions filed in the Supreme Court over alleged hate speech by him. The court didn't go into the merits then. It asked the petitioners to go to the High Court and also made the broader point that the Supreme Court shouldn't become a political battleground every election season. That batch is currently pending before the Guwahati High Court.
For our next story, the Sabarimala reference hearings continued this week with day 9 and day 10 before the Supreme Court. So, Awstika, what happened on day 9 first?
Day 9 was significant because it effectively saw the review petitioners and interveners on that side wrap up their arguments. Advocate Nizam Pasha, appearing for the direct descendant in the Chishti Nizami lineage associated with the Nizamuddin Dargah, made a fairly clear case that if you don't share a religion's beliefs, you don't have a constitutional right to enter its place of worship. He argued that Article 25 cannot override the autonomy of a religious denomination under Article 26, which is placed on a higher pedestal. He also touched on constitutional morality, saying courts shouldn't define it in the first instance and that there has to be some legislative anchor before the judiciary steps in to test it. There were also some interesting illustrations from other counsel. One advocate referred to the Kamakhya temple in Assam, where menstruation is celebrated and women serve as priests, to show how practices can vary widely across traditions. And then there was a more conceptual argument that Lord Ayyappa as a juristic person has civil rights and that those rights are exercised through devotees who can decide who is allowed entry.
And day 10 brought the other side, Indira Jai Singh representing the women who entered the temple in 2018.
Yes. And her argument was very different in tone. She said that individual rights under Article 25 must prevail and that courts can't take a hands-off approach when fundamental rights are at stake. She also made it very personal. She spoke about growing up in a home where menstruating women were treated as impure, not allowed to touch others or even sit at the dining table. And she connected that to Sabarimala, arguing that the idea of women defiling the temple is a form of untouchability under Article 17. That prompted some pushback from the bench as well. Justice Nagaratna cautioned that reform should not end up hollowing out the religion itself. And there was one exchange that really captured the tension of the day. Justice Nagaratna asked, does custom prevail or one woman's desire? To which Indira Jaising responded, this isn't about desire, it's about freedom.
Big constitutional questions, and the hearing is still ongoing. For detailed day-by-day coverage, head to livelawmedia.in. The Allahabad High Court this week refused to direct an FIR against leader of the opposition Rahul Gandhi. The Sambal court had already refused, and the High Court agreed. What's the legal reasoning here?
This case arose from a speech in which Rahul Gandhi used the phrase, fighting the Indian state, which a petitioner construed as seditious or inflammatory and sought an FIR on that basis. The Allahabad High Court has rejected the plea, and it has done so on two clear grounds. First, criticism of the government is not a criminal offence, that is settled law. Second, and this is the more nuanced part, the court drew a distinction between fighting against an ideology and inciting rebellion against the state. The word fight in ordinary political discourse signifies advocacy, protest, or opposition. It does not by itself connote armed insurrection or an attempt to subvert the state. The court found that Gandhi's remarks fell squarely in the category of political and ideological opposition, not sedition.
Does this fit into the broader pattern of courts tightening the threshold for what courts count as sedition or incitement?
I wouldn't put it as courts uniformly tightening the threshold because that's not always consistent. But in my view, there is definitely a conscious effort, at least in some of these cases, to push back against the use of criminal law for political speech. And in these cases, what the courts are really asking is a basic question. Does this speech actually cross the line? Does it promote enmity or incite violence? Or is it just something that those in power find uncomfortable? In this case, the court seems to have taken the view that it falls in the second category, and that's why it stepped in to protect liberty at the stage of arrest.
We close our top stories with the Allahabad High Court and some notably sharp language from Justice Atul Sridharan. The immediate context was a madrasa case involving the NHRC, but what the judge said went well beyond that.
Debojeet, the case before the court was a petition by a Teachers Association of Madrasas challenging an NHRC inquiry into UP madrasas. But Justice Sridharan used the occasion to make a pointed observation that has drawn considerable attention. He said it was surprising, his word, that the NHRC has been active in ordering inquiries into UP madrasas, but has taken no suo motu action on incidents of lynching and vigilantism targeting interfaith couples. He put it vividly, having coffee in public becomes a fearful act for interfaith couples. He was directly criticizing what he perceived as the NHRC's selective activism, or rather its silence on one category of rights violation while being active on another.
And what I think what's important here is to understand Justice Sridharan's broader approach. His recent observations on interfaith couples show a clear concern for minority rights and personal freedoms. He had previously also dealt with questions around religious practices, right?
Yes. In an earlier decision, Justice Sridharan had taken a fairly strong position that individuals do not need prior permission from the state to offer prayers on private property. The emphasis there was on protecting personal religious freedom and keeping the state from unnecessarily interfering in private acts of worship.
And there's been a development on that position this week as well.
Yes, there has. A division bench of the Allahabad High Court has now clarified those observations. The court said that while people are absolutely free to pray in private spaces, that protection is limited to activity that is genuinely private and non-disruptive. Once it becomes regular, organized or large scale, something that begins to affect the public at large, it is no longer just a private matter. At that point, the state is entitled to step in and regulate it in the interest of public order.
That's our top story segment. Let's move quickly through the week's quick updates. For activist Teesta Setulwad, the passport continues to stay where it is with the state.
The Supreme Court declined to release Teesta Setulwad's passport this week, noting that no definite foreign travel plan had been placed before it. The court left open the possibility of approaching it again when a concrete travel purpose can be shown, but for now, the request has been turned down. 9,400
WhatsApp accounts wiped out, all of them linked to digital arrest scams.
The Ministry of Home Affairs informed the Supreme Court that WhatsApp has banned 9,400 accounts connected to the digital arrest scam operations that have been targeting and defrauding citizens. These scams involve criminals impersonating law enforcement officers to extort money. The Supreme Court continues to monitor this issue as part of its broader scrutiny of fraud involving forged documents.
A 193-acre plot in Thane that the Bombay High Court had released from acquisition. The Supreme Court has put that on hold.
The Bombay High Court had released this 193-acre stretch of Thane land from acquisition, treating it as a private forest. The Supreme Court has stayed that judgment, meaning the land remains under acquisition while the matter is further examined. The Thane Municipal Corporation is among the parties in this dispute.
A ruling that every litigant in arbitration needs to hear. You cannot run to the court the moment an arbitrator rejects your jurisdiction challenge.
The Supreme Court has clarified that there is no immediate right to challenge an arbitrator's rejection of a plea questioning the tribunal's jurisdiction. You must wait for the final award and raise the jurisdiction question in the challenge to that award. This reinforces the principle of minimum curial intervention. Courts should not be drawn into ongoing arbitration proceedings prematurely.
The Supreme Court has taken suo motu cognizance of something that insolvency practitioners have been saying for years. The IBC's promise of time-bound resolution in practice is impossible to achieve.
The court has formally taken cognizance of the systemic problem of NCLT delays in approving resolution plans, delays that fundamentally undermine the IBC's core promise of speed. This suo motu action signals the court's intention to address a structural issue directly. It is a significant intervention because it goes beyond any individual case to the functioning of the insolvency system as a whole.
Next, a clean IBC ruling. Corporate guarantees firmly qualify as financial debt.
The Supreme Court has held that a corporate guarantee constitutes financial debt under the IBC. This matters for determining who can initiate insolvency proceedings and how claims are ranked in the resolution waterfall. The State Bank of India was a party in this case, which should give a sense of the practical significance of the ruling.
Former Kerala Minister Anthony Raju was convicted in an evidence tampering case. This matter has reached the Supreme Court,
which has dismissed his plea to suspend the conviction, meaning it stands in full force.
Remember Satinder Singh Bhasin, whose bail the Supreme Court cancelled for misusing company funds? What's the latest there?
Despite having his bail cancelled, Bhasin has not surrendered to custody. The Supreme Court has questioned the UP police for failing to arrest him and has summoned the DGP. A person whose bail has been cancelled is legally obligated to surrender, and when the police fail to enforce that, the court's authority is directly implicated. This follows the court's earlier finding that Bhasin had used company funds to deposit the 50 crore bail condition, a violation both of his bail terms and of the Companies Act.
Something a little different. The fate of the deers at Delhi's A.N. Jha Park has been decided by the Supreme Court.
The Supreme Court has approved the shifting of the deer from Delhi's A.N. Jha Park to Rajasthan. And it has directed that retention of up to 38 deer at the deer park, as recommended by the Central Empowered Committee, shall be permissible only subject to the grant of requisite approvals and clearances by the Central Zoo Authority. But not only this, it has also gone further and directed the centre to frame broader guidelines on wildlife relocation from urban spaces. So this individual decision will serve as a foundation for a national framework on how wildlife in cities is handled when relocation becomes necessary.
If you bought a property based on a will that later turned out to be forged, can you be held criminally liable?
The Supreme Court this week said no. A bona fide purchaser who bought property acting in good faith on a will that was subsequently found to be forged cannot be held criminally liable, the Supreme Court has held. The key element is the purchaser's state of mind at the time of purchase. If there was no reason to know and no reasonable means of verifying that the will was forged, criminal culpability simply does not attach.
And next, we have an important judgment from the Supreme Court this week relating to summary judgments in commercial suits.
Under Order 13A of the CPC, commercial courts can dispose of suits summarily without a full trial in cases where there is no genuine factual dispute. The Supreme Court has now issued guidelines clarifying when and how this power can be exercised. The ruling came in the Reliance Eminent Trading case involving a dispute with the Delhi Development Authority. So the court has now said that the judges must first ask, does either side actually have a real chance of succeeding? Or is the claim or defense speculative or weak? It has also cautioned courts against turning this into a mini trial. You don't go into detailed evidence or witness credibility at this stage. You only see whether a full trial is even necessary. At the same time, the court has said that this power should be used carefully and in exceptional cases because it cuts short the usual trial process. But where the facts are clear, documents are undisputed, and a trial would only delay the inevitable, courts should not hesitate to decide the matter upfront.
How do we determine that someone is brain dead? That may seem like a purely medical question, but it's now a judicial one too.
The Supreme Court has directed AIIMS to constitute an expert committee to explore alternatives to the current method of brain death verification. This came up in a petition that questioned the adequacy of existing protocols. The committee's findings could have downstream implications for transplant medicine and organ donation law.
Next, a step forward in the representation of the Supreme Court Bar Association.
Yes. The Supreme Court has directed that the SCBA Vice President post be earmarked for women advocates in the 2026 Executive Committee election, a small but meaningful gesture towards addressing the gender gap at the leadership levels of the bar.
A blow for advocates who had been counting the days to the advocates on record examination.
Yes. The Supreme Court has notified that the AOR examination will not be held in 2026, with the next exam likely in 2027. Those who have been preparing may need to reset the timelines by at least a year, but this matter has already come to the Supreme Court on the wings of a challenge as per latest developments.
From the Delhi liquor policy case, first, Arvind Kejriwal invoked Gandhi and Satyagraha to boycott his own hearing. And then Manish Sisodia followed suit. Both refused to appear before Justice Swarnakant Sharma.
Yes. And this comes after both of them had already tried a legal route before taking this step. They had filed recusal applications, if you remember, asking Justice Swarnakanta Sharma to step aside from hearing the case on the ground of a perceived apprehension of bias. Now, just to explain, recusal is when a judge voluntarily withdraws from a case if there is a reasonable apprehension that they may not appear impartial. But the key point is, the decision to recuse ultimately lies with the judge herself. In this case, Justice Sharma rejected those applications and decided to continue hearing the matter. After that, both Kejriwal and Sisodia chose to boycott the proceedings. Kejriwal has framed it as a form of protest, like you said, invoking Gandhian Satyagraha, saying that he cannot in good conscience participate in a hearing where he feels there is an appearance of bias. But legally, that doesn't stop the court. If an accused or a party chooses not to appear, the proceedings don't automatically pause. The court can continue to hear the matter and pass orders based on the record.
We close on a landmark moment for India's judiciary. Sikkim has been declared the country's first fully paperless state judiciary.
At the National Conclave on Technology and Judicial Education, the Chief Justice of India formally declared Sikkim as India's first paperless state judiciary. For a small state, it's a considerable achievement and it sets a benchmark that others will now be measured against as the push for court digitization gathers pace across the country.
And that's a wrap on this week's Courts This Week. This is Debojeet Das signing off with Advocate Awstika Das. For detailed coverage of every case we've discussed today, head over to www.livelaw.in and follow us on all our socials to stay updated on everything that is law. See you next week.